On March 7, 2020, 23-year-old Keelan Hawkins was arrested in Harris County, Texas, and charged with driving while intoxicated DWI. That same day, she was released under a general order bond, a system established by Harris County Local Rule 9. This rule mandates that, with the exception of defendants falling into certain carve-out categories, all individuals arrested for misdemeanor offenses must be promptly released on an unsecured personal bond, meaning no upfront payment is required, and a judge's pre-approval is necessary. In practice, this means that for most misdemeanor arrests in Harris County, release happens automatically. The sheriff's office is instructed to release qualifying defendants without a hearing or monetary bond. Harris County's general order bond system is notable because it was created as part of a consent decree issued on November 21, 2019, following the 2016 federal class action lawsuit O'Donnell v. Harris County. That lawsuit argued that the county's previous misdemeanor bail practices were unconstitutional, leading to sweeping bail reforms designed to ensure fair and equal treatment regardless of financial status. After her release on the general order bond, Hawkins's arraignment was scheduled for March 13, 2020, before Judge David Flecker. The hearing would determine whether there was probable cause to proceed with the DWI charge and whether any adjustments to her bond conditions were necessary. Although Greg Holton was listed as Hawkins's primary defense attorney, his colleague Garen White appeared on her behalf at the arraignment.
Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver, and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
It's just she had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds. Ma'am, you're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for now.
After determining that there was probable cause to support the DWI charge, Judge David Flecker imposed several conditions on Keelan Hawkins's bond. Specifically, he ordered that she not consume any alcohol and not operate any motor vehicle while her case was pending. This went beyond what the prosecution had requested in its written motion, which only sought to require Hawkins to install an ignition, interlock device ID, a breathalyzer system that prevents a car from starting if the driver's breath shows any trace of alcohol. Under Article 17.441 of the Texas Code of Criminal Procedure, courts are required to order the installation of an IID for defendants charged with repeat DWI offenses or aggravated cases, such as DWI with a child passenger. However, since Hawkins was a first-time DWI defendant, that article did not compel the judge to impose an IID requirement in her case. That said, Article 17.40 of the same code grants judges broad discretion to impose any reasonable bond condition that is related to public or community safety. While judges are prohibited from using bond conditions as a form of pretrial punishment, Texas appellate courts have consistently upheld such conditions when they serve a legitimate safety purpose. In fact, the 14th Court of Appeals in Houston clarified in the 2020 case of Ex parte Bucks that appellate courts review challenges to bond conditions under an abuse of discretion standard, meaning a trial judge's ruling will stand as long as it falls within the zone of reasonable disagreement. In Hawkins's situation, the allegations that she had been driving while intoxicated and had an open container of alcohol in her vehicle made Judge Flecker's restrictions appear directly tied to concerns about public safety. Therefore, it is highly likely that an appellate court would find his decision, forbidding her from drinking or driving, to be reasonable, lawful, and well within his discretion.
Understood. Judge.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously. I don't want you to talk here now in front of him. You know, you guys at a later date can come back. I'm always all ears. Like, it's not
For
absolute.
Greg's purposes, since he's going to be the one representing her, what is a later date? I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue. I mean,
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know? But it's something that I've seen more and more, you know, where there's alcohol in the car, and I would presume that you would know, especially at this age, that, you know.
well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the DIM summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal limit.
During the arraignment, defense attorney Aaron White requested that the court grant Keelan Hawkins limited driving privileges, allowing her to drive to and from work while her case was pending. However, Judge David Flecker declined to modify the existing bond terms, maintaining the complete driving prohibition, at least for the time being. It's important to understand that bond conditions restricting driving are legally distinct from the status of a person's driver's license under Texas's administrative license revocation process. At the time of this hearing, Hawkins's blood test results had not yet been returned, which meant her driver's license had not yet been suspended through administrative action. Nevertheless, under Article 17.40 of the Texas Code of Criminal Procedure, judges have wide discretion to impose reasonable bond conditions that promote community safety. This gives a judge the authority to completely prohibit a defendant from driving, or alternatively, to permit restricted driving, such as commuting to and from work, while forbidding any other use of a vehicle if, at a later point, Hawkins's blood alcohol concentration back results came back showing a level of 0.08% or higher. The Texas Department of Public Safety, DPS, would then be required to suspend her driver's license under Section 524.012 of the Texas Transportation Code. That statute mandates an automatic suspension when a driver's BAC exceeds the legal limit. Even if Judge Flecker were to lift or modify her bond restriction at that stage, Hawkins would still not be legally allowed to drive while her license was suspended. Her only option would be to apply for an occupational driver's license ODL under Section 521.242 of the Texas Transportation Code, a special, limited license that permits individuals to drive solely for essential purposes, such as work, school, or necessary household duties. Despite an active suspension,